Now, the first thing when you open a public gambling act, so you will find this definition, which is very important. Why? Because if you are somebody who will consult a client on gaming, a startup on gaming, if you're in-house of a gaming company, if you are looking at an FIR which has been filed against an organization which is dealing into gaming, the first thing you need to know is this definition. So what is this? I'll read it and I'll explain of how I have been dealing. So all the examples which I've given is my life experiences in this gaming company where we have referred to this definition. Okay, I've dealt with FIRs, I've dealt with opinions, I've dealt with other kind of PILs and litigations at different various courts of the country, and we have to deal with this. Hence, I place this definition here. So it is about the common gaming house, which means any house, room, tent, walled enclosure, space, vehicle, vessel, or any place whatsoever in which any instrument of gaming, instrument can be cards, dice, and everything, okay, is kept or used for the profit or gain of the person owning, occupying, using, or keeping such house, room, tent, enclosure, space, vehicle, vessel, or place, whether by way of charge for the use of such house, room, tent, enclosure, whatever. Then it says gaming or gambling includes wagering or betting. This is the title of the act, says Public Gambling Act. So gaming, or if you put it in any other sense, or a game of skill, is an exception to the Public Gambling Act. That is what we need to get very clear, that whatever is happening in the digital world, if it has that element of skill, it is an exception and it will not fall under the definition of gambling. Okay, so let's go to see 3 and 4 and 5. Yeah, can we jump to, yeah. So if you see, the third provision in this act is speaking to the penalty. So it says that if we find you in any closed space, we find you in any room, tent, even if it's a garage or if it's a hotel room. So FIRs are created by such ways only, okay? They go and raid at places if people are playing in the hotel rooms, or, they're playing in their own houses, and so if they think it's a walled room, if it is a closed space, they define it as a common gaming space. But so is not the nature if the same can be classified as a game of skill. So what happens if somebody is put under such situation? What can be the penalty around it? So earlier it was said that it shall be, I'm reading the last point, shall be liable to a fine not exceeding 200 rupees or to imprisonment of either description as defined in the IPC for any term not exceeding 3 months. So do you see, these are so, what should I say, non-existing kind of law that is still existing and has called for changes. However, the penalty is just 200 rupees or imprisonment, which may not be more than 3 months, right? So, and then it's saying one is penalty for owning or keeping or having charge. So say you are in a hotel room, so the manager can be also charged. Okay, if you are doing it, if you're playing in a house, so the owner of the house can be held charged for it. And then the penalty for being found in a gaming house. So whoever is found in any such house, so if somebody is operating a gaming zone only, that can be a gaming house. So it says whoever is found in any such house, walled enclosure, room, place, playing or gaming with cards. So these are the instruments and the tools: dice, counters, money, or the instruments of gaming, or is found there present for the purpose of gaming, whether playing for money, wager, stake, or otherwise, shall be liable to a fine of so and only 100 rupees to minimum imprisonment of either description as may be defined in the IPC, or for not exceeding a period of a month. So outdated laws, I don't have much to say here, but yes, that's what the provision says. But coming back again, that we need to understand where does gaming finds its exception and on what basis. So let's look at section 12. Can we jump to section 12? Yeah. So see, it says act not apply to certain games. Nothing in the foregoing provisions of this act contained shall be held to apply to any game of mere skill wherever played. Now, who will define what is mere skill? Certainly the courts. So now let's look at the Bible of this industry, without which this industry cannot exist. Again, if you are consulting, freelancing, you are in-house, you are an executive, you are the VP, head, legal, whatever, you will have to know these landmark judgments by heart. If you are somebody who is looking forward to being a gaming lawyer in the future, you should know these judgments, because if you quote them also, you are opening a world of opportunities. You are putting yourself an edge above the others. Okay, let's jump back to the PPT, please. So section 12 of the PGA is where you understand that gaming with skill has been created as an exception to gambling, betting, or wagering. And then if it is involved with money, stakes, or wagering, it has been termed as a business activity, which we will see in this next slide. Yeah, next slide, please, Vanshika. Yes, so this is one judgment which you should just read it, because the way it has spoken about all the factors of gaming, without this judgment, this industry is baseless. Okay, it spoke about Article 19(1)(g), calling that game of skills a business activity. Hence, you cannot say that you're doing something illegal. Then game of skills, when played for stakes or earning profit, would be a legal business venture and would not amount to gambling. So these are the words quoted from the judgment for you here. And then this case laid down by the Supreme Court said that a dominant factor test must be adopted to determine that a game where the success of the player is dependent on substantial degree of skill, even if there is an element of chance, will be termed as a game of skill. So this case set in the rule of how to determine whether a game would be called a game of skill or whether it will be called a game of chance. How? It said that you have a dominant factor. If the skill is dominant in that game in a respect to comparison to chance, it will be a game of skill. Simple. So if there is, the word they have uses, if there is preponderance of skill over chance, it will be determined as a game of skill. So any time from today, it means there are so n number of digital games that are coming up in the in the arena. Every day you go out and you see another new game coming up on one platform, apart from fantasy. So how, as a lawyer, would you determine or suggest your client that yes, this will be categorized as a game of skill, and you have all the right to continue allowing it to the public at large and continue it as a business activity? So you will have to see whether it is having the dominant factor of skill. And how do you do that? To understand that a game is game of a skill, very simple. Are you strategizing? Are you analyzing? Are you calculating? Is your mind being put into your use? Are you deciding through your intellect? Yeah. Are you observing other person's skills? Yeah. Are you understanding the moves or the nature or the behavioral patterns of the other side and then taking your calls? All of this, when your mind is coming into play, it means that you're applying your senses, you're applying your skills, right? Of course, it is not ruled out that there will not be the chance of luck. A luck factor will come into play. We never rule that out. But is it heavily weighing over skill, or the skill is heavily weighing over chance? If the skill part is substantial, is heavily loaded, then it's a clear case of a game of skill. And that is how this industry is surviving. Okay, so further, the last line of this is also very nice. It says the exercise of judgment, discretion, and reason has also been determined to be exercise of skill, to be exercises of skill. So it says when you're judging, when you are using your discretion, when you are reasoning, these all factors are also factors of skill. And if these are coming into place, then it's a game of skill. right? So in this case, it was, I think it was, it was a game of skill being defined as a business activity. So this is where, if today, if I have seen some 50 litigations around this industry, there's not a single PIL, there's not a single counter affidavit, or there's not a single reply which goes without these judgments. Yeah, we have sets of these judgments handy all the time. Without these judgments, this industry is nothing. Let's move up to the next one. So this is the first of its kind. I'm going to speak about the next two, which is State of Andhra Pradesh versus K. Satyanarayana case. Okay, it was in 1968. It was deciding on the game of Rummy. So the game, Rummy is very interesting to me because it has been an undisputed war till today. Though a fair judgment, that too by the Supreme Court, has been laid down in 1968, but still the war is on. But in this, it was a settled law. It said that this game involving skills such as the memorizing of cards, folding them, discarding them, sufficiently qualifies it as a game of skill for the purpose of gaming and gambling statute. It made it very clear that somebody is using the mind, they're using the intellect, they're using the discretion, strategizing, analyze. So where do you not find that the skill is in use, right? Chance is a mere thing. The person is all playing it and on its mind. So it is a game of skill. Let's move ahead.